កម្មវិធីកិច្ចសន្ទនាកម្ពុជានិងពិភពលោក
Good evening, Excellency, ladies and gentlemen. Welcome once again to Cambodia Global Dialogue or Southeast Asia TV. Tonight, I have the pleasure to have a long-time friend. He's not old, but you know, he's a long-time friend, Dr. Prom Virat, who is a professor of law teaching now at CamEd, right? Business School, yes. So we're gonna talk tonight more related to something that you probably not used in the show because we get a bit more micro, right, into the legal aspect of employment in terms of contract. I don't know. We'll cover later. But I want to put the context a bit why I thought it's an important topic because you know we in the ASEAN economic community now. You know, it's a lot of migration in, migration out, foreign investor coming in, employment issue. We also going out, work in other ASEAN country. So I think the issue of a contract, employment contract matter, and it'd be good to have a good understanding. What is Cambodia employment law, labor law to be precise? I like to think more on a larger employment law than just labor law. But anyway, before we start, why don't I give you a few minutes to introduce yourself?
Thank you. Thank you so much for having me tonight. My name is Virak. So I have a law background here back in 2000. Then I went to Japan for my master's and PhD. And after that, I worked a while. And then I was in Toronto, Canada, where I did another thing this time, not on law or politics. This time I did on human resource management. So that's why the idea of employment law or labor industry really comes to my mind. So really a big opportunity for me, so thank you for having me tonight.
Well, it's a pleasure. I think years ago I was a teacher also, right?
Yes, you were my teacher,
yes,
of course.
So that was long time ago, way back in the early 90s, right? You went to Rule or NIM?
I went to Rule.
Rule, yes.
And graduated in 2000.
Yes, great. Good. Well, you know, but in terms of in Cambodia, we only have the labor law, but I think but the context is quite understandable. The economy just really kickstart after the peace process. ILO came in and helped us draft a labor code. I mean, it's more a code than just a simple law there. And at that time, the gist of the labor law was more to gear to the growing of the garment industry. We don't even have footwear yet at that time, so it's a lot of more about worker, that sort of thing. But I think I think the economy is more than just garment worker, footwear worker, right? In those days, it was like that. But anyway, what's your perspective way back then from that employment aspect?
Yes, of course, as you just mentioned, I think back because our law was adopted in 1997. So I think back then our economy was just starting to open up. So we were expecting more and more incoming investors coming in, and of course, obviously, when foreign people coming in, the question they would ask is, does Cambodia have skills? And therefore, my view is that the law back then, although it stands at, you know, it was good then and it's still good today, but there are some things that need changing. And that's why today I'm very keen to talk about some particular clauses that you would usually see in a labor contract.
Yes.
For example, something that we call non-competition clause,
yes.
which you usually see.
Yes.
And one more matter that happens all the time, you see people go on strike. They have their labor contracts suspended, so on and so on. So I think these two areas are perhaps what investors think a lot about, because when they come to your country, they want to make sure first that they can get the best they can get. Secondly, what is the movement like?
Yeah, yeah.
Does our law restrict the movement, or does our law open
What do you mean by movement? What movement?
For example, when you work in a company now, you usually happens with big companies. They usually have a clause that say you cannot work for a competitor.
Yes.
After you
Okay,
leave me.
that's what I mean by movement. Yes. Okay. Well, yeah. I think in most of other advanced economy, it's we sort of take for granted, right? Yeah. You sign a contract with a company more for competitive reason. Yeah. They don't want you to go and to take the knowledge or the training that you have acquired in their place to go to work for the competitor. Do you see that a lot in the Cambodian contract?
I have seen it quite a bit, and I think the trend is growing. And it's concerning from our point of view, because we are lawyer by training. Then we look at it because our law actually does not recognize.
Oh, is that right?
This is very important because it's clearly in our law.
The law is silent or doesn't recognize?
The law does not recognize. It says clearly any clause that prohibits workers from engaging in competitive work after they leave the job is void.
But see, this is where I always have some issue in terms of definitional aspect of worker. Yeah. Because the law, you have to have the context. Yeah. What's a law cover, right? The coverage in those days, and that's why the law needs some refining, some updating, some retweaking, because in those days it was more for government worker. Yeah. The profession, liberal profession, lawyer, accountant, engineer, whatever, it doesn't exist yet in those days. But we are so-called professional, right? I don't think I want to call myself a worker. But what do you think of that?
I think you are exactly right. But and that's why now there's been more and more willingness to look into that law, and particularly in that clause, because we know that it is there regardless.
Yes.
You might like it or you don't like it, but it is there regardless. So that's why recently I wrote an article, particularly on that, saying although our law does not recognize it, yes, we have to make sure that things are happening. Yes. And in the future, I think sooner rather than later, we have to amend that. And if we have to amend it, then what are the considerations that we have to take into account? Yes. So I look at it from what exists in other countries, in particular in France. Yes, yes. So I looked at it, and even France, that thing is still very new. It only started to gain more focus back in 90s. Is that right? In 1992, big case in France changed everything, and then 10 years later, 2002, another big case to re-establish what they mean by non-competition clause. And I think now France is a lot better. Well,
it's quite interesting because France is a civil law country. Yes. It's more code-driven, right? More code-driven. Yeah, so you're telling me that now they look also from the president's stare decisis?
Yes, yes. So interesting. France now, although it's by definition a civil law country, but their jurisprudence works very, very well. And in fact, in a lot of the fields that they use, people would just look at what are the decisions made by the Supreme Court. Yes. In that country, they call Cour de Cassation, but that's what it means. So I think common law and civil law really
you start to see emerge, right? Yes. Well, you're right that it's a lot of debate about the dichotomy of the two systems, but I see a lot of area of convergence. Right. Civil law country, like you said, look at the Cour de Cassation in terms of precedents, and then in common law country like U.S., California, for example, have their code. Then you have the UCC, Uniform Commercial Code. It's a bit gray now, I would say, right? I would say.
Yep. Civil law, common law. Now, if we look at what or in which way they are different, not so much.
Not so much.
Because at the end of the day, when investors come in, they want to make sure that their contract will be enforceable. Yes. So maybe from that point of view only, we try to think. I myself tend to think common law is a bit more favorable, friendly to investors, because if investors coming in, if they know that in your country this is how the court will decide. If they know that in advance,
Yes.
then they're very confident. They say,
Yes.
okay, then I just make sure that my contract follows the precedents of the court, then I will be fine.
But how about a freedom of contract? I mean, I go apply for a job.
Yeah.
I really want that job, but the company say, look, our business is very, I would say, heavy on intellectual property, on IP matter. We have a lot of trade secret. It requires a lot of training for you to learn the business, and we sure don't want you a year later to take all this knowledge to go across Phnom Penh and get another job with our competitor.
Sure.
If I want a job, I sign.
Sure.
If I stick with the law, I don't sign, then I don't get a job. What's your view on that?
This is very tricky, and in fact, I think the trickiest would comes when people start suing each other. Now we know that there is this clause,
Yes.
very quite common now, but I haven't heard of any case as yet,
Yes.
which would allow the court to look at it and say, okay, how do we implement this particular clause in the law? Do we stick to that very, very narrowly,
But it's
or we have to
untested, no?
interpret it?
But it's untested, no?
It remains as untested now as it was. But if you take France as an example,
Yes.
in the past, in the 70s, the court would just use one criteria only, which is as long as the clause is limited enough in time and in space, then that should be fine. Meaning you cannot prohibit somebody from doing anything for the rest of their life in
Yes.
time. You cannot do that, or you cannot prohibit someone for doing a job anywhere in France. No, that's not possible. So if you want that clause to be enforceable, make sure that it is limited enough in scope. Let's say one particular area of Paris,
Yes,
and
yes.
limited in time,
Geographical,
right? And limited in
scope.
time, maybe 1 or 2 years,
Yes,
not
yes.
longer than
Yes.
that. But that in the past, now they have more and more conditions to make it even more difficult.
Is that right? In what way?
For
They
that-
they remove what?
So they keep that as it is.
Yeah.
So first condition, it must not be unlimited either in time or in space. And then second condition that came in 1992, a big case that say, fine, but not only that, if you want that clause to be enforceable,
Yeah.
the company had to make sure that they could justify to the court
Yes.
that this is to protect their legitimate interests of the enterprise.
Okay.
If the clause cannot protect, it's not meant to protect the legitimate interests of the enterprise, forget it.
All right. We're going to take a short break, and we'll come back. We'll continue this very interesting dialogue. So okay, so the trend is more toward removing the restriction or enforcing, deepening.
It,
Okay.
enforcing it more deeply.
In favor of.
Right now, you could say in favor of more and more for the employer, right?
For the employer.
Because the condition they say, you just have to justify that it protects the interest. It might go both ways. It
Yes,
might go
yes.
both ways. Yeah. So, for example, I'll give you an example at that time, because that case involved a gentleman who is a cleaner of the window.
Yes,
right?
yes.
So cleaner
worker,
of the
right?
window, right? Cleaner of the window, and yet his contract has that clause.
Yes.
So the courts would look at it saying, oh, well, it doesn't make sense. A cleaner wouldn't know any trade secrets. A
Yes,
cleaner
yes.
wouldn't know any technical knowledge
Yes,
that,
yeah.
that they have to worry about. Therefore, the court came down with a new decision saying you could only restrict if it really to protect your legitimate interest. It might still sound pretty vague, right?
Yes.
What
And
is legitimate interest of
Yes.
the company?
Yes, yes.
So I think, as you mentioned earlier, if you're in an industry that requires some specific skill, then I think maybe it's a bit easier for the company to justify.
So in this case, what was the interest? I mean, the prevailing interest of the employer to restrict that?
Because back then the employer, I think they were still used to the idea that they could restrict as long as you have the time and space.
Yes.
But then the court say, well, now we are in the in '92
Yeah,
now.
yeah.
Things have changed a bit.
Yeah.
People need to
Mobility.
big,
Yeah.
more
It's
bigger.
the word mobility.
And that's right. So then they say we have to make sure that you can enforce that anytime, anywhere.
Yes.
Plus you have to justify. But then the thing didn't stop there. Right? People were not still happy. So 10 years later, 2002, the same court came up with another condition. Right. So up until now you have unlimited, limited in time and space. Now you have to justify to the court that this is to protect the legitimate interests of the company. But now a new one add another condition. So now it's toward employees. Another condition that you have to pay. If you want to restrict somebody,
You have to compensate.
you have to compensate.
Okay.
So that is more and more now.
But-
So it makes the enforcement of that clause more and more costly.
But I mean, you use the example in France, which is very socialist, driven society, right?
Of course.
But what happened in the U.S., which is a very an employment at will, society.
In the U.S., it's perhaps, I'm not expert of the U.S. system, but I think in the U.S. maybe it's less tricky because,
Yes.
but still, the idea of protecting the legitimate interests of the company, that should be quite universal. I think you want to restrict somebody because you
But
have to
only
protect-
if you have in writing. Only
Only if you have in
it's a
writing.
contract issue.
Yes.
It's a contract issue. And that's why they in employment contract you better read the fine line.
Better read the blueprint also.
Yeah.
Yes.
You better read. But it's still a employment at will in the U.S. So and that's why you see all the time in. I exaggerate a bit in the movie, right? In many movies, say, well, you're fired, right? That sort of thing in The Apprentice show, right? So that is one trend. But in the case of Cambodia, I'm still a bit concerned that this definitional vagueness of what do you define as a worker, in a garment factory, a footwear factory, versus a professional work for a big accounting firm or a big engineering firm. It's a bit. I mean, you cannot do this to a garment worker who live in Kandal and who want to go to work in Kampong Speu. You cannot do that, right? I mean, people leave all the time,
Yeah. Definitions. In terms of definition, I think because we usually tend to say a few things. Worker, somebody that use force, use hand, use force, right? The physical, and that's why we have different categories. Even the categories that would apply to trial periods.
Yes.
For workers, it should be just 1 month, right? For specialized employees, it should be 2 months. For all the rest, it should be up to 3 months as trial period.
Yeah.
And the idea of having 1 month only as trial period for
Probationary
workers,
period, we call
probationary period for workers, because we know that they don't require too much skill. So 1 month is enough for you to see whether he or she can work, right? So I think that's the idea. But regardless, that clause is still there, and it's very concerning. And a lot of people don't know about that. And when
are government owner enforcing that though?
Not really.
Not really.
I do not think people think too much about it. First thing, because perhaps they don't even know that the law does not recognize. And second, maybe they just feel well about people need a job, so let them do. And,
Yeah. All right. So I think that settled the matter. That ultimately, it's up to the employer.
Sure.
If it doesn't know, well, you don't know. And sometimes it doesn't really matter when you have 2,000 workers in a factory and one person decides to leave. I think it's not outcome determinant per se. Yeah. All right. So what's the other subject you want to talk about, which you think are important in the context of our employment law?
Before we move on to another subject, I would like to say another condition that the French again say now not only you have to pay, but usually what the judge would do is they look at all the specs, all these specifications of that job.
Yes.
So before the judge would really validate the clause, he must think, okay, how old is the worker? How big is the job market? How easy for him to find another job? What is his title? What is his seniority in that company? Because the judge play around a bit before they can say, okay, if you want to restrict them, 1 year only in this particular area only. So they can either enlarge the prohibited area with a shorter time, or extend the time with a smaller geographic area. Right now, the next subject.
I mean, let me cut you on this a bit. In my view, I think the overreaching of the sort of like the state institution here. I mean more than just the court in France. I'm talking in France, the state. The policy. It's really, if you look at from the larger macroeconomic perspective as a socialist country, if you talk to employer and I talk to a lot of French employer, they are not happy because it's very easy to hide, but it's very difficult to fire.
Sure.
I have a cousin. She's a dentist. She's a Cambodian, right? I mean, she's a dentist. Every time I call her, she's always on vacation. I said, well, you don't pull people's teeth. She say, well, cousin, I just work enough. After that, I'm better off going on vacation because the system is not encouraging me, to work harder. I have, it's so difficult to fire people. So I don't want to get into that. But the point is that in a competitive market, right, I'm more in favor of a less restricted, system that allow people more freedom to move around. Of course, I think there have to be fair compensation, but it should be straightforward, right?
Yes.
And in our labor law, we have, like you mentioned, right, this 1 month, 2 months, 3 months, and then it's quite a complicated formula. Huh? Because when we have clients who want to let go people, I mean, my God, I mean,
sure.
By the time you finish all the criteria, you could go broke.
Sure.
But I guess we follow the French model.
Of course. Now, the next issue I would like to talk about is the suspension of employment contracts.
Okay.
Our law elaborates a dozen grounds on which a suspension could be triggered. Your contract may be suspended if you go on military service.
Yes.
I think we have this but it just doesn't apply too much. Or either employer or employee go on that military service, then your contract is suspended. Or you are sick. But
let's go back a bit on the definitional side again. Is that the one is a contract with definite period, and the other one is a contract with indefinite period, right? So here you're talking about which one?
The suspension goes both ways.
Go both ways. Okay, good.
So there are a lot of grounds. You're either sick, you go to serve the country. Either you're pregnant in case of female workers. Or
maternity.
Either because your internal regulations have some regulation that talk about what kind of discipline could lead to suspension. But those things don't happen too much. What we have observed, specifically in our country, is that you could suspend the contract if you are having an economic hardship. If an enterprise is facing with serious material economic hardship, they could suspend. Not lay off. They could suspend. They could suspend the employment contract for up to 2 months.
Okay.
So the first condition, suspension cannot last longer than 2 months. Second condition is that this one has to be under the control of the labor inspector.
Okay.
Now, I think the first condition is quite straightforward.
Yes.
Right? But the second condition is much more tricky.
Okay. I think we're going to take another break, and when we come back, we'll tackle this interesting subject. All right. So here you're talking about suspension of an individual employee. Okay,
Yeah.
Go ahead.
As I said before, things could happen. First question you might ask is this a good thing? When somebody go around suspending somebody else's contract, is that a good thing? I would argue yes, it might be a good solution, a good temporary solution, especially in bad times, such as when the employer has a difficult economic situation.
But how do I know that the employer had a bad time? He still drive a nice car, the business is still good, and if you look at that, right? You look at Siem Reap. I mean, you have all this hotel. There's low season, there's high season. Low season, everybody is no business. So would that qualify as a hardship, temporary hardship?
Now, I could only talk about the case that we have had.
Yes.
I think because the Labor Arbitration Council
Uh-huh.
has made a lot of good decisions, and which I think now.
But for the Labor Arbitration Council, they're more on collective, collective case, right?
Yes.
Not just an individual, no?
Not just individual. Normally not individual.
Okay.
Usually it's only collective, but there
Yeah.
are certain cases where they also hear individual.
Okay. They do
cases.
here, okay.
Yes. So now in terms of economic hardship, they have handled so many cases. Now their jurisprudence is quite clear.
Uh-huh.
So when they say this thing has to be under control of labor inspector, they require two conditions. First,
Okay.
they have to inform the inspector in advance.
Okay.
Say, hey sir, we would like to suspend. And second, you have to receive prior approval by the inspector before the suspension takes place. Or else, if either of these fails, you have to pay in full
During the suspension.
during suspension. Although nobody worked, you have to pay in full.
Interesting.
If you do not obey these two. Right? So I
okay.
think it's very important for the employer. Now, as you ask, how do you know that somebody is facing a hard time? You still drive a new car. Interestingly, the Arbitration Council, when you talk about what criterion that they use, it's very case by case scenario, right?
Yeah.
For example, in the garment industry, that happens a lot, when they don't get enough purchase orders, right?
Yeah.
For a certain period of time, they suspend. Then for arbitrators, that usually qualify as economic hardship,
Okay.
which could
Yes,
justify suspension. But make sure that they don't go longer than 2 months.
Then 2 months, right?
Than 2 months per year. Not
year.
2 months per time, 2 months per year.
Per year. You mean it can be 3 times as long as it doesn't exceed
months in
2
total.
months. So it's like a visa. You know, when you go to some other country, they say, well, not multiple, but not exceed 3 months, something like this. But the, how you actually implement it is quite tricky, no? I mean, you take off 1 week, suspension 1 week, because I don't have order now, right? And then 3 months later, you take off another 2 weeks. I mean, a bit hard for the employee, no?
It's hard maybe for both. For the employee, yes,
Yes.
it's not nice to have your contract suspended because during suspension there's
Without
no
pay.
pay. There's no pay.
Okay. Yes.
No work, no pay.
No work, no pay.
It's simple, right?
Yeah.
So and therefore, I think the state is very careful when they say because no work, no pay. You make sure that your suspension is legal, and which brings into play the role, very important role of the labor inspector.
Yeah.
So that's why they say labor inspector must be controlling, in the sense that every single time a suspension happens, the controller, the labor inspector better keep checking. Hey, how is you doing now?
Yes,
Can
yes.
they come back to work? I think so. The system is meant to create dialogue.
Okay.
In theory, right?
Yes,
in practice,
in theory,
how that
yeah,
happens, maybe it's tricky, but I think in theory, at least that meant to create a lot of dialogue. So labor inspector and the employer have to be constantly talking, right? And I would hope that the labor inspector would do his job.
Yes.
Right? Keep checking, hey,
Yes.
how are you doing now?
When you mention no work, no pay, I can't help but to think of a song called No Woman, No Cry. That's by, I don't know, by a Jamaican famous,
Sure.
what's his name? I don't know. Well, but from the Labor Arbitration Council, they have developed a precedent, right?
I have the work precedent.
How many subject area of precedent by now the council have established?
It's quite a lot, I think. For example, they have defined pretty well what is leave,
Okay.
what are the components of the salary,
Yes.
when, for example, what are the boundaries of your power to manage. That is another issue. In fact, if we have time, we can talk about it. Because usually when you sign up for a labor contract, then somehow you reduce your own freedom, and the employer will have to sort of the power to manage you. But then you ask, to what extent you can manage me?
Yes, yes.
Because not because I'm your employee, I become your slave. No,
Yes,
it's not
yes,
like that, right?
yes.
So, but for example, in the case of transfer, now you sign a contract. Some contracts say nothing about possible transfer. Some contracts clearly say that the employer reserves the right to transfer you to other locations, to other branches.
Yes.
But even that, the arbitration council has been very clear that when there is a clause that says you can transfer people, that clause is not automatically enforceable. Because it doesn't mean that when people sign up to a contract with that clause, it doesn't mean that they will agree to transfer to wherever. So you have to make sure that your clause is well defined in scope and in space. And that's why they came down with a good precedent, I'd say. They say you must meet 4 conditions. They're very good at making precedents, right? First, you cannot lower the salary. So transfer is okay as long as there's no reduction of salary.
Okay.
Second, you cannot change the shift from day to night, night to day.
Okay.
Third, you cannot transfer to a place that's very far from your home.
Okay.
And fourth, the transfer should not lead to change too much to your skills. For example, if I am an IT, you cannot change me and put me become sales manager. For example.
But what happens if one of the conditions, say for example, the factory is in Kampong Speu and they move you to go to Saang, for example, which
Kandal,
is
right?
Kandal, right? What happens if the distance to travel is further and there's a cost involved on a daily commute, for example?
Interestingly, I can tell you one case in which a man was being transferred from Kampot to Phnom Penh,
Yeah.
and the arbitration say no. The arbitration
Yes,
say no, it's too far
It's
to
too
move
far,
somebody
yes.
from Kampot to Phnom Penh.
Yeah.
Although the company was willing to pay for
Okay.
the house in Phnom
Okay.
Penh, but
There's all the hardship,
right,
the kids,
because
the family, and everything.
all of that, and
Yes.
then the arbitration say no, we can't do that.
Yes.
So usually, if you transfer somebody to another place, make sure that you meet those 4 criteria, right?
Interesting.
No pay reduction,
Yes, yes.
no change from day to night or night to day, no change too much to your skills, and make sure that it's not too far.
Yes.
What is not too far is not clearly defined, but I think it's always case by case, as you just mentioned. A single perhaps could move more freely
Sure.
than a married man, right?
Sure,
So I
sure.
think all of these things would have to be taken into
Yes.
account.
Well, so all in all, Cambodia is a civil law country. I mean, we swing back, full swing to a civil law country, because after the peace process, when we have to rebuild our legal system, there's a lot of confluence or influence of ad hoc, common law influence, particularly in the commercial area.
You were part of it.
Yes, I know. Because I think in those days it's a sort of we have too much love. Everybody loves us. All the donor loves us, but every donor have their own
Agenda.
I think to be fair to them, some have, some don't. Some just happen to have a system of their own. And when they send their advisor, by default they send, their own people. So their own people are coming with a certain background, which when you're on a short term or even 1 year assignment, you're not gonna, sort of like change or take the time to reflect, the actual local condition in the country. Basically, you just push whatever you know, right? If you know a certain law, you're comfortable with certain law in your country, you come to say, look, this is the law, this is a draft, and in those days, and I keep saying those days because the human resource capacity to appreciate the difference between legal system are not there. So you end up having a lot of people who meant well, but it turned out that the outcome was very confusing to the country itself. Confusing, not that dramatic, okay? But still, I think that now with the Japan coming to 10 year, to bring back the civil code, civil procedure, France helping us get the criminal code, criminal code of criminal procedure, it sort of consolidate, the pendulum swing back to Cambodia being a civilized country. I think in the commercial area we still have to deal with commercial contract drafted by Singaporean or British law firm who bring a certain concept, like for example the trust concept, which in Cambodia is a civil law country, we don't have it. We have other notion, but it's not something that is applicable. But I thought it'd be interesting, to just inject that few thought, because in our discussion the last couple 45 some minutes, we touched about employment law, but which is more a civil law driven country. To me, at the end, right? I mean, it took me a long time to realize that Cambodia being a post-crisis country, even though we're some 20 years after the peace process, it's good to be back in the civil law, because at least you have a code, right? I mean, when in doubt, you have a code.
Sure.
You may not like that provision, but at least
it's there.
See, so it is less subject to the interpretation of the code. So it's more on us, as citizens, as India, to read. Okay, if I'm going to be transferred, there are 4 conditions, as you mentioned, right? Sure. Is that 4 provision, can I live with it or not? See? But at least deep down, right? I'm going to look at the article. What's your last word or message?
Well, I think as Cambodia is moving towards a better system, legalistically speaking, we are moving towards a better rule of law country, and I would suggest that every stakeholder would need to study the law more and more. Not because I'm a lawyer by training, I say that, but because I find this is critically important, that you have to know your rights and then use them effectively. And also at the same time, some areas of laws need amending. In this case, the non-competition clause that our law does not recognize, and I think our law should recognize it in the future to allow for more mobility.
Yeah, mobility, that's the word.
So I think, from that point of view, it's true that we had legal transplant from foreigners in the past, but now the past is past, right? Now we have to live with it, and we have to keep amending to make sure that it reflects our realities.
Yes. Yeah. Well, it's such a pleasure to have you on this subject, even though we only have 45 minutes to touch on 2 important subjects that I agree with you, we should look in the future. But I really appreciate your last point that you say, the past is the past, that we have all this legal transplant. But I think by now, and you sitting here as a former student of mine, now a professor of law, a doctor, me here, having gone through all this development process, and God knows how many other Cambodians who are well educated, coming back, gone through the learning curve, and we do see what works, what doesn't work. To be fair to our development partner who help us in good heart, I think it rests upon us as Cambodians to start to see what are the area, because we cannot say that your transplant doesn't work, okay? It works to a certain extent, but there are areas that we need to tweak to reflect our culture, to reflect our local reality, and also more than anything now in the context of a regional and globalized economy, to reflect the trend of the employment world. Now we're talking about the fourth industrial revolution, robotic, software app,
cyber,
employment, that sort of thing. How do we look at our own legislation and comment to our own policymaker, our own lawmaker, to say, well, we should change 3 or 4 articles. The rest is okay. The rest is a framework, but this will be very conducive to our economy. And I will close by giving one good example. Our land law, for example, right? For many years, the real estate development did not take off. The commercial real estate development did not take off because of a constitutional prohibition of having land ownership by foreigner, which is great. I support totally. But then, one trigger change that trigger the whole real estate landscape that transformed Phnom Penh from a horizontal capital to a vertical capital, with all these high-rise sprucing up everywhere, was a change to allow a strata title that foreigner still cannot own land, but they can own an apartment on the 15th floor or whatever. And then certainly investor came, build it high, do a joint venture with a Cambodian who owned the land. But then it opened the floodgate to foreign investor to come and buy an apartment. It enabled a Chinese or Singaporean factory manager to now live in a condominium. So you see, these are to me the positive thinking that occasionally happen, and we should be on the lookout on how we can provide that additional input for our economy to thrive. So once again, thank you so much, and I really enjoy it. And next time we'll further on other sub-issue related to employment law. All right.
Thank you.
Well, we're coming to the end of the show, and I'm not going to summarize as usual, but I think this is quite an interesting topic, and one of the things that come to mind is that a labor law that was adopted in 1997. It's been 20 years now. The economy at that time was still closed and small. Now we are in ASEAN Economic Community. We're in a moment where even industry are moving, sort of like away from a labor-intensive garment footwear industry toward a more industrialized with the industrial development policy. So things have changed, right? So this discussion today sort of like give us a taste a bit on what are some of the areas that we may have to tweak our labor law to reflect the current and the future condition of the economy. So good night.